So Trump lackey Kash Patel has been granted immunity and ordered to testify to a federal grand jury about Donald Trump's classified documents crimes. But what happens next? Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So close Trump associate, this guy, Kash Patel, who also happens to be a former Devin Nunes flunky, has been granted immunity and ordered to appear and testify before a federal grand jury investigating Donald Trump's classified documents crimes. Here is the new reporting by Hugo Lowell of The Guardian. Headline: Top Trump advisor granted immunity for testifying in Mar-a-Lago papers case. Kash Patel will receive limited immunity protection from prosecution for his testimony on how and if the documents were declassified. And that article begins, federal prosecutors examining Donald Trump's unauthorized retention of highly sensitive government documents at his Mar-a-Lago property will obtain testimony from top advisor Kash Patel after granting him limited immunity from prosecution, according to two sources familiar with the matter. The immunity, a powerful tool that forces witnesses to testify on the promise that they will not be prosecuted for their statements or for information derived from their statements, takes effect on 2 November and signals the importance of his testimony to the criminal investigation. The Justice Department's interest with Patel centers on his claims that the documents found at Mar-a-Lago were declassified, how the documents came to end up at the property, and how Trump's aides and lawyers responded to requests for their return, the sources said. Okay, friends, let's break this down. When do issues of immunity typically arise? I want to use a somewhat routine, real-world example. Let me use a murder investigation as a vehicle. This is something I encountered many times in prosecuting homicide cases. Let's say I have a target of the investigation, the person I believe committed the crime, the homicide. And let's say I want to subpoena that person's girlfriend because I believe she has information relevant to the investigation of the murder. We subpoena the witness, the girlfriend. She comes into the grand jury. She's placed under oath, and she says, I plead the fifth. Now, why might a witness plead the fifth? Well, usually one of two reasons. The real reason somebody is allowed or entitled to invoke their Fifth Amendment right against self-incrimination is because their truthful testimony would tend to make it look like they committed a crime. And the Constitution provides that no person can be compelled to be a witness against themselves in a criminal case. No person can be forced with a subpoena or otherwise to incriminate themselves. So let's assume that what the girlfriend did and what she knows and why she's pleading the fifth is because she gave her boyfriend the gun before he committed the murder weapon and she drove him away from the scene of the crime, right? That makes her criminally involved in a couple of different ways, potentially, in the murder. So she pleads the fifth. That's a viable invocation of the Fifth Amendment. There's another reason witnesses, in my experience, plead the fifth. It's because they don't want to testify. Now, let's assume the same witness, the target's girlfriend, did nothing wrong, didn't give him the gun, didn't drive him away, has absolutely no involvement in the murder, but she pleads the fifth anyway. Well, then what we do is we take the witness and the witness's attorney and we go before the chief judge and we litigate whether the witness actually has a Fifth Amendment right to invoke or not. And if the witness doesn't, if the chief judge decides, no, she just doesn't want to testify against her boyfriend, but she doesn't have information that would incriminate her if she was forced to testify, then the judge will basically reject the privilege and order the witness to testify. But sometimes we have to litigate that before the chief judge, all of which is secret. These are grand jury matters, so the public doesn't get to attend or know what's going on in this Fifth Amendment litigation. But this is pretty routine. So now, let's apply this to what we know about Kash Patel. Kash Patel announced to the world, Donald Trump declassified all these documents. Well, no, he didn't. And we all know that he didn't. There's no evidence of it, and there would be. Every document, both hard copy and in any electronic database, would have to be marked declassified. There's a process to follow. You can't just think it declassified and it's magically declassified. So it seems like Kash Patel may have lied to everybody about Donald Trump declassifying these documents. And friends, do you believe for a minute Kash Patel just spontaneously came up with this on his own? You know what, let me just say Donald Trump declassified everything, because that will make him seem less culpable for all this stuff that he stole from the White House and unlawfully concealed at Mar-a-Lago. If he at least declassified it all, it's still a crime, but still, maybe Kash Patel was trying to mitigate the damage for Donald Trump. So naturally, the prosecutors want to interview and place before the grand jury Kash Patel, because he was making these outlandish claims for which there is no evidentiary support. So they went before Chief Judge Beryl Howell. And here's what she ruled, and there's pretty hard reporting on this. She ruled that, wait, Kash Patel does have a viable Fifth Amendment right against self-incrimination, so you federal prosecutors, you can't force him to testify unless you grant him immunity. So then prosecutors have a tough decision to make. So let me back up, because once the judge sustained Kash Patel's Fifth Amendment right against self-incrimination, that means Kash Patel probably committed crimes. And if he were to testify truthfully, his statements would tend to incriminate him. Put a pin in that. Now the prosecutors have a decision to make. There are basically two things that prosecutors can do once a judge sustains a witness's Fifth Amendment right against self-incrimination. We can grant the witness immunity. But trust me, prosecutors really don't like immunity, and I'll tell you why in a minute. Or we can try to charge the person with the crimes that he committed, with the crimes that are giving rise to his Fifth Amendment right against self-incrimination. Because if we can charge the witness with his crimes, we can negotiate a guilty plea with cooperation, and then we can use him, flip him, so to speak, against the bigger criminal fish, in this case, Donald Trump. But prosecutors don't necessarily always have enough evidence to go that route, to indict, to negotiate a guilty plea with cooperation, to flip the witness. So they're kind of left with immunity if they really want the information. And it seems like the federal prosecutors really want the information Kash Patel can provide about Donald Trump's classified documents crimes. Sometimes we break down and grant the witness immunity. Now, why do I say prosecutors hate to grant immunity? At least this prosecutor did. Because if you grant somebody immunity, you're giving them a pass for their crimes. And then if you want to take that person and use him in the future in a criminal prosecution against Donald Trump, he is going to experience withering cross-examination. Wait a minute. Kash, you expect us to believe your testimony about the crimes of other people when you were given a pass for your own crimes? These prosecutors didn't even make you plead guilty and take responsibility for your own crimes? If you didn't have to take responsibility for your own crimes, why are we going to believe anything you say about the crimes of others. You'll say anything these prosecutors want you to say. They're the ones who did you that solid, gave you that pass. That's an example, condensed version of what would be a lengthy cross-examination of an immunized witness. So I don't like granting immunity to witnesses if I can help it. You know, it also has to do with holding people accountable for their crimes, which is kind of the mission of the prosecutor. But sometimes we have to. And it looks like the prosecutors calculated that we want Kash Patel's evidence about Donald Trump's classified documents crime so much we're willing to grant him immunity. And immunity extinguishes your Fifth Amendment right against self-incrimination. Why? Because immunity says we can't use your statements against you. You can say you committed all sorts of crimes and your testimony, your admissions can't be used against you, so you don't have a Fifth Amendment right against self-incrimination. So that is where we are at this moment. Now, let me finish with this, friends, because last night I was on with Lawrence O'Donnell, one of my favorites, and we were talking about the immunity for Kash Patel and where things stand. And he asked me, Glenn, what happens if after he's granted immunity, he goes into the grand jury and he starts telling a bunch of lies? He's not willing to talk truthfully about the crimes of Donald Trump or his own crimes for that matter. What happens then? And here's what I said. My answer was, I breathe a sigh of relief. And you know why? I mean, yes, it would be wonderful if Kash Patel walked in and decided to do the right thing. How often do close associates of Donald Trump decide to do the right thing by the American people, by our democracy? Come on now. This is a Trump flunky. But it would be wonderful if he said, yes, let me tell you about the documents crimes I know Donald Trump committed, perhaps that I participated in, that I facilitated with my lies about how he declassified them. So if Kash Patel goes in and starts telling a whole bunch of lies under that grant of immunity, guess what? Immunity does not protect you from perjury. Immunity is not a license to lie. Immunity is a license to tell the truth without the truth being used against you. So if Kash Patel goes in there and tells a bunch of lies, what are the odds in his determination to protect his man Donald Trump? I breathe a sigh of relief because now I have a golden opportunity that I didn't have when I had to grant him immunity. I can charge him with perjury, falsely testifying before the grand jury. I can potentially charge him with obstructing justice, the criminal investigation into Donald Trump's classified documents crimes, because he's lying to my grand jury. He is obstructing that criminal probe. I can potentially charge him with accessory after the fact because he's trying to help Donald Trump get away with his crimes. It is perhaps evidence that Kash Patel continues to be part of a conspiracy with Donald Trump to commit any number of crimes. And now what can I do? Now I can charge him. Now I can negotiate a guilty plea with cooperation because now I have leverage. Leverage that I didn't have when I was stuck and had to grant him immunity. If I had to bet $1 of my own money, friends, I'm not a high roller, $1 is my betting limit, I would bet $1. Kash will appear before the grand jury and dig himself a nice little criminal hole by lying about a man that he said, hey, Donald Trump is my ride or die guy. Kash Patel has made statements to that effect. I'm taking liberties. He said, I am sticking with him through thick and thin. So let Kash Patel go in there, lie to the grand jury, obstruct the investigation, serve as an accessory after the fact, prove he's an ongoing co-conspirator. All good, Kash. Then justice will come for you. And justice matters. Friends, as always, please stay safe, please stay tuned. And I look forward to talking with you all again tomorrow.